The letter didn't just change my life. It lit a fuse. One moment, I was half awake in my kitchen, coffee going cold, bills stacked like bad decisions. The next, my hands were shaking over an envelope so expensive it felt arrogant. Embossed. Heavy. Legal. That's when I knew this wasn't good news. Or maybe it was the kind of news that comes with consequences. Inside was one sentence that made my stomach drop. You are the sole beneficiary. Not of money. Not of a house. Of land. A lot of land. I hadn't thought about my great-uncle in decades. The family ghost. The man everyone called Eccentric because it was easier than saying unsettling. He vanished into the Blue Ridge foothills before I was born, sent postcards once a year, and showed up exactly twice in my life, both times like he didn't belong among normal people. And now? Now he'd left everything to me. When the attorney called later that day, his voice was calm. Too calm. The kind of voice people use when they're about to ruin your sense of reality. Ms. Harper, he said, your inheritance consists of approximately 1,200 acres. I laughed. I actually laughed. Because that's absurd, right? 1,200 acres isn't land. It's a kingdom. Then he added the sentence that changed the tone completely. There is a complication. Every HOA horror story starts with a complication. He explained it slowly, methodically, like a surgeon explaining where the blade will go. 15 years ago, a residential development was built near your uncle's land. A nice one. Gated. An HOA. Whispering Pines. 47 homes. Clubhouse. Pool. Tennis courts. Playground. Perfect lawns trimmed within an inch of their lives. Only problem? They weren't near my land. They were on it. The county maps were wrong. The title company missed it. And the HOA, the HOA, built an entire suburban paradise on property they never owned. Legally speaking, every single homeowner was trespassing. I didn't say anything for a long time, because my brain was busy rebooting. So, what does that mean? I finally asked. The attorney exhaled. That means, he said, the entire Whispering Pines HOA sits on land you now control. Control. That word echoed. My great-uncle knew. Found out 3 years ago. Started legal action. Then died before finishing it. Which meant the fight, the war, was now mine. 3 weeks later, I stood at the edge of a hill, looking down at Whispering Pines for the first time. It was beautiful. Symmetrical houses. Identical mailboxes. Flags flying at regulation height. HOA perfection. And every inch of it was built on land that belonged to me. I imagined the HOA board meetings, the fines, the rules about trash cans and grass length, all enforced by people who didn't even own the ground beneath their feet. That's when I realized something important. They thought they were in control, and they had no idea who they were dealing with, because I wasn't there to negotiate landscaping rules. I was there to decide what happens when an HOA picks a fight with the actual landowner. And the first letter I sent them? The first letter I sent wasn't angry. That's what made it terrifying. It was polite, professional, surgical, no threats, no drama, just facts. I informed the Whispering Pines HOA that I was the rightful owner of the land beneath their entire development. I attached certified surveys, county corrections, legal documentation stamped so many times it looked bruised. Then I ended with one line that I knew would land like a grenade in an HOA boardroom. This letter serves as formal notice of trespass. I mailed it certified, signature required, because I wanted proof that someone, somewhere, felt the moment their world tilted. It took exactly 4 days for the response. Not from a lawyer. Not from the county. From the HOA president. Subject line: urgent, land ownership error. That alone told me everything. The email was condescending in that special HOA way. Lots of words. Zero accountability. They thanked me for bringing the matter to their attention, assured me it was clearly a clerical mistake, and confidently stated that Whispering Pines had been established in good faith, and therefore I had no actionable claim. They ended by suggesting that I consult an attorney before causing unnecessary alarm among residents. I stared at the screen, stunned. They weren't scared. They were annoyed. That's when I realized something crucial about HOA Karens. They don't respond to reality. They respond to authority. And they believed they were the authority. So I hired my own attorney, a property litigation specialist who didn't smile much and asked exactly the right questions. When I showed him the maps, he leaned back slowly. "Do you know what you have here?" he asked. "A headache, I guess." He shook his head. "You have leverage. Apparently, good faith doesn't mean much when you're standing on someone else's land. Trespass is trespass, even if it comes with manicured lawns and a community pool. And the kicker? I wasn't required to sell. I wasn't required to negotiate. I wasn't required to be reasonable. I could demand back rent. I could revoke access roads. I could restrict utilities that crossed my property. Or, I could do something far worse. I could enforce my rights slowly. The second letter went out a week later. This one came from my attorney. It was longer, sharper, less polite. It outlined 3 options for the HOA. Option 1. Purchase the land at market value plus 15 years of back use. Option 2. Enter a lease agreement with monthly payments and strict conditions. Option 3. Vacate. 47 homes, families, mortgages. Vacate. We gave them 30 days to respond. That's when the panic started. I began getting emails from residents, not the board. Homeowners. Confused, angry, afraid. Is this real? My house is paid off. What does this mean? The HOA says you're trying to extort us. Ah yes. Classic HOA move. They told residents I was a scammer, that I was exaggerating, that it would all go away. So I did something the HOA never expected. I showed up. One Saturday morning, I parked outside the Whispering Pines clubhouse. I didn't announce myself. I just stood there while residents gathered for their weekly HOA meeting. And when the president finally noticed me, I handed her a copy of the survey and said, loud enough for everyone to hear, "Good morning. I'm the person who owns the ground under your feet." The silence was instant. You could hear the pool filter humming. And then someone asked the question every HOA fears. "Wait, does that mean she can tell us what to do?" I smiled. "Not yet," I said. "But I can decide how long you stay." That was the moment Whispering Pines stopped being a peaceful suburb and became a battlefield. If you've ever watched an HOA lose control in real time, it's almost beautiful. The president, Deborah, according to her embroidered name tag, recovered first. HOA leaders always do. Control is their oxygen. She cleared her throat and smiled the kind of smile meant to put people back in their assigned boxes. "This meeting is for residents only," she said sharply. "You're causing unnecessary panic." Unnecessary. I hadn't even started. "I'm here because every single resident deserves to know the truth," I replied. Calm. Even. Especially before the HOA collects another dollar from them. That hit a nerve. You could feel the crowd shift. Murmurs. Side eyes. Phones coming out. HOA Karen energy doesn't survive sunlight. Deborah tried to steer the meeting back to lawn violations and trash can placement, but it was over. Once homeowners smell deception, they don't care about hedge height. Someone asked, "Have we been paying HOA fees for land we don't own?" Another followed, "Does that mean the clubhouse isn't ours either?" I didn't answer. I didn't need to. Their own attorney, sitting awkwardly in the back, stood up. And that's when things escalated. He confirmed it. Carefully. Legally. Publicly. Yes, the land ownership was disputed. Yes, surveys favored me. No, there was no immediate resolution. The word disputed spread like gasoline. Deborah's face tightened. The mask cracked. After the meeting, she cornered me outside. You are destroying a community, she hissed. I tilted my head. No, I said. Your HOA did that when it built on land it didn't own. She warned me that the board would fight this aggressively. That they had resources. That they'd bury me in paperwork. I almost laughed. HOAs think paperwork is power. 2 days later, my attorney filed formal notice with the county. 3 days after that, utility companies received letters informing them that access easements crossed privately owned land, my land, and would need to be renegotiated. Suddenly, Whispering Pines wasn't just a neighborhood. It was a liability. The HOA board scrambled. Emergency meetings, special assessments, closed-door sessions that ran past midnight. And then came the move that sealed their fate. They fined me. I wish I were joking. They issued a violation notice, mailed to my home address, citing unauthorized interference with HOA operations. They fined me $500. I stared at the letter for a full minute. Then I framed it. Because nothing proves HOA arrogance like attempting to fine the person who owns their foundation. That fine became Exhibit A in court. And the judge? He did not appreciate irony. At the preliminary hearing, the HOA's attorney argued community reliance and shared responsibility. My attorney stood up and asked one question. Do you deny that every structure in Whispering Pines sits on my client's land? Silence. The judge leaned forward. So, he said slowly, you've been collecting dues, enforcing rules, and issuing fines on property you do not own? Deborah didn't look at me. The judge ordered mediation. Mandatory. That's when the HOA's tone changed. Suddenly, they wanted to work together. To find a fair solution. But by then, I'd already found mine. Because buried in the original development plans was something they'd overlooked. Something small, technical, and absolutely devastating. The only access road to Whispering Pines? It crossed land that wasn't included in any easement. Land my great-uncle never granted permission for. Land that now belonged to me. Which meant, legally, I could control who entered and when. And the letter informing them of that? It went out the next morning. The access road changed everything. Until that moment, Whispering Pines had treated me like an inconvenience. A paperwork problem. Something their HOA lawyers could outlast with fees and stalling. But when my attorney's letter landed, clearly stating that the only road in and out of the development crossed privately owned land with no recorded easement, the power dynamic flipped overnight. Because HOAs can ignore emails. They can spin narratives. They can bully residents. But they cannot ignore roads. Without legal access, mortgages panic. Insurance companies panic harder. And banks? Banks don't panic. They pull funding. Within 48 hours, I got my first real phone call. Not an email. Not a notice. A call. From Deborah. Her voice was different now. Softer. Measured. Like someone walking on ice they didn't know was thin until it cracked. We need to talk, she said. We've been talking, I replied. You just didn't like what I was saying. She asked for a meeting. Neutral ground. Mediation friendly. I agreed, but only if their attorney and the full HOA board attended. Because I wasn't negotiating with one HOA Karen anymore. I was dealing with an organization that had trapped 47 families in a legal nightmare. The meeting was held in a rented conference room at a nearby hotel. Long table. Water pitchers no one touched. Tension thick enough to taste. Their attorney opened with a rehearsed speech about cooperation and community values. I let him finish. Then I slid a document across the table. A proposed temporary access agreement. It allowed residents to use the road, for now. In exchange, monthly payments, strict terms, and a clause stating I could revoke access with 90 days' notice if negotiations failed. Deborah's eyes widened. This is extortion, she snapped. No, I said calmly. This is rent. Their attorney tried to argue necessity. Habitual use. Implied permission. My attorney shut that down in one sentence. Permission is not implied when the owner never granted it. Silence. Then came the real fear. One of the board members asked quietly, "If we don't agree, what happens?" I looked directly at him. "Then your residents will need to find another way home." That's when the HOA cracked. They agreed to the temporary access agreement. But the residents? They didn't know yet. And that's when the emails exploded. Homeowners found out that their HOA had failed to secure land right, that their dues had never gone toward ownership, that their houses, beautiful, expensive houses, were legally sitting on borrowed ground. Some were furious at me. But most? They were furious at the HOA. Emergency town halls, group chats, lawyers hired by residents themselves. Deborah tried to spin it, claimed she was protecting the community. But HOA Karens only stay powerful when people believe them. Once trust breaks, it shatters. Then came the moment that shifted everything. A resident named Mark, quiet guy, never involved in HOA drama, stood up at a meeting and asked one simple question. "Why are we paying you when she owns the land?" No one answered. 2 weeks later, 15 households stopped paying HOA dues. The HOA responded with threats, liens, penalties, legal action. Bad move. Because my attorney filed a motion challenging the HOA's authority to levy fines on land it didn't own. And the judge? He allowed it. Which meant the HOA's enforcement power, their entire identity, was now under legal review. Deborah called me again that night. This time, there was no edge in her voice. "Please," she said, "let's settle this." I leaned back in my chair. "Now," I replied, "you're ready to listen." But the settlement I had in mind? It wasn't what they expected. And it was going to cost them far more than money. By the time negotiations restarted, Whispering Pines wasn't united anymore. It was fractured. Half the residents wanted peace, any deal that kept their homes safe. The other half wanted blood. Specifically, the HOA boards. And the board? They wanted out. They came to the table exhausted, defensive, no longer pretending they had leverage. Deborah didn't even bring her embroidered name tag this time. Their attorney asked what I wanted. I didn't answer right away. Instead, I asked a question of my own. "Do you know why my great-uncle never sold this land?" They exchanged glances. "He didn't trust institutions," I continued. "Especially ones that claimed control without accountability." That landed. Then I told them my terms. Not a buyout. Not a lease. A transfer. I would sell the land beneath Whispering Pines, not to the HOA, but to a newly formed land trust controlled by the residents themselves. The HOA would lose ownership authority, lose enforcement power, lose its ability to fine, threaten, or bully. The HOA would remain, but only as a voluntary maintenance association. No liens, no penalties, no Karen rulebook nonsense. Deborah looked like she'd been punched. "You're dismantling us," she said. "Yes," I replied. "I'm freeing them." The land trust would collect minimal fees. Transparent. Audited. No secret reserves. No surprise assessments. And one more condition. The current HOA board had to resign. Immediately. Every single one of them. That's when Deborah stood up. "You can't expect us to agree to that," she said. I slid another document forward. A breakdown of back rent, legal exposure, potential damages, and a note from my attorney estimating how long the access agreement would remain valid if negotiations collapsed. Deborah sat back down. They asked for 24 hours. I gave them 12. The residents forced their hand. Emergency vote. Board members shouted down. Accusations flew. One board member walked out in tears. By morning, the HOA caved. Every board member resigned. The land trust was approved. And Whispering Pines, once ruled by bylaws and fines, changed overnight. But the story doesn't end there. Because once the HOA's power vanished, something unexpected happened. The residents started talking. Really talking. About where their money had gone. About past fines. About selective enforcement. And they found things. Things that didn't add up. One resident uncovered expense reports. Another found contractor kickback. Another noticed that Deborah's house had never received a violation notice, ever. The residents hired a forensic accountant. And that's when the quiet phone call came. Not from Deborah, from her lawyer. He asked, very carefully, whether I'd be willing to testify. Because the HOA problem? It had turned into something else entirely. Something criminal. And suddenly, I wasn't just the landowner. I was the witness who could finish it. I never planned to testify against anyone. I just wanted my land back. But HOA Karens have a way of dragging everyone into the mess they create. When Deborah's lawyer called, his voice was careful. Too careful. The kind of careful that means someone is already in damage control mode. There may have been irregularities, he said. Your cooperation could help clarify certain misunderstandings. Misunderstandings. That's what people call fraud before indictment. I met with the resident's attorney first. Smart move. He laid it out plainly. The forensic accountant had found years of inflated contract. Landscaping companies owned by friends. Emergency repairs that never happened. Legal fees paid to firms that never filed anything. And at the center of it all? Deborah. The HOA Karen who fined people for trash cans and mailbox paint, had been quietly siphoning money while pretending to protect community standards. Here's the twist no one expected. Because the HOA never owned the land, their authority to collect dues was already shaky. Which meant every dollar collected under false pretenses. Potentially recoverable. The residents were furious. Not internet angry. Not complaint angry. Lawsuit angry. I agreed to testify. Not out of revenge, but because I'd already seen what unchecked HOA power does to people. And because Deborah had tried to find me. The deposition was brutal. Deborah sat across the table, no name tag, no authority, no audience. Just a woman realizing her control had evaporated. They asked about her selective enforcement, her conflict of interest, her failure to disclose land ownership issues. Then they asked about me. Why did you attempt to find the landowner? The attorney asked. She didn't answer. She couldn't. Because there is no explanation that doesn't sound insane. 2 months later, the settlement was announced. Deborah resigned permanently from any HOA position. She repaid a significant portion of misused funds, and the HOA insurance covered the rest. Whispering Pines residents received refunds. Not huge ones, but symbolic. Enough to matter. Enough to prove something important. Once the HOA was stripped of unchecked authority, the community didn't collapse. It improved. People helped each other. Rules became suggestions. Meetings became conversations, not tribunals. And the land trust? It worked. No drama. No fines. Just shared responsibility. As for me? I sold the remaining acreage to a conservation group, at a fair price, honoring my great-uncle's wishes to protect the land. Except for one small parcel. The farmhouse. I kept that. I fixed it up. Sat on the porch some evenings. Watched the sun set over land that had nearly been stolen by paperwork and arrogance. Sometimes, residents from Whispering Pines wave as they drive by, on the road they're allowed to use because it's finally done right. Deborah moved away. I heard she tried to join another HOA board in a nearby county. Didn't last long. Turns out reputations travel faster than moving trucks. Here's the lesson most HOA Karens never learn. Authority only works when it's legitimate. And control? Control disappears the moment someone finally checks the paperwork. Because sometimes the quiet person with the deed is the most powerful one in the room. And I wasn't playing nice. I was playing correct. One part remains. The final fallout and the message every HOA needs to hear. The funny thing about power is this. Most people don't realize who actually has it. For years, Whispering Pines believed the HOA was untouchable. The board set the rules. The board enforced the fines. The board decided who was in compliance and who wasn't. And nobody questioned it. Because HOA authority feels permanent. Until someone asks one uncomfortable question. Who owns the land? Once that question surfaced, everything unraveled. The lawsuits ended quietly. No headlines. No sirens. Just signatures and sealed agreement. That's how HOA empires fall. Not with explosions, but with audit. The residents moved on faster than anyone expected. Gardens replaced warning notices. Neighborhood cookouts replaced violation letters. People who had lived next door for years finally spoke like equals, not defendant. And the irony? Property values didn't drop. They rose. Turns out buyers like communities without predatory HOA. Every now and then, someone asks me if I feel bad. After all, I appended 47 households. I dismantled an HOA. I exposed a board president. Here's the truth. I didn't destroy a community. I gave it back to the people who lived there. The HOA had one job: protect the residents. Instead, it protected itself. And when confronted with the truth, it chose arrogance over accountability. That's why it lost. If there's one reason I'm telling this story, it's not to celebrate revenge. It's a warning. Check your deeds. Question authority. Never assume the loudest person in the room is the most powerful. Because somewhere out there, another HOA Karen is issuing fines on land she doesn't own, confident that no one will challenge her. And somewhere else? Someone just inherited paperwork that says otherwise. Power doesn't always announce itself. Sometimes it arrives in a quiet envelope on a Tuesday morning and changes everything.